Well, I can tell you at Landlord Action we are really busy. We've seen an increase in rent arrears from landlords wanting to take action to gain possession of their property, and I think obviously the cost of living crisis is kicking in. We had our busiest December ever in history. We're also seeing a big increase of the amount of landlords that are serving Section 21 notices. Mainly when we do ask the landlords, why are you serving Section 21, the main reason has been because they want to sell their property or antisocial behaviour. If your tenant is in arrears, you need to try and engage with them. Obviously, if they don't engage with you, it's really hard to start some sort of mediation. Mediation is the best form of a first tool to try and sort out the issue of unpaid rent arrears. Why is your tenant fallen into arrears? What's the reason? Is it housing benefit or universal credit? Or has the tenant lost their job, or do they have lots of other debts? You need to have really good communication lines, and if your tenant is sincere and want to stay in the property, they will be quite open with you. It becomes a last resort in serving an eviction notice and going to court and getting a bailiff eviction date if your tenant is refusing to engage with you, and of course the rent arrears are naturally building up months upon months. 2 months rent arrears is a mandatory ground. So if your rent is due on the 1st of October, by the 2nd of November, that's 2 months rent arrears, because in a tenancy agreement, the rent is due payable in advance. And that is a mandatory ground, a ground 8, where the judge has to grant a possession order if you do have to go to court. So normally you should be looking at starting the eviction process and serving a Section 8 14-day notice between 2 and 3 months rent arrears. There's a Section 8 notice which is for breach of tenancy. Normally a landlord would serve that notice when there's rent arrears, at least 2 months rent arrears, or at the moment it could be antisocial behaviour or breach of tenancy. The other notice being served is called a Section 21 notice, which they call non-fault, and the main reason why a landlord would serve the 2 month notice would be to end the contract because they wish to move back in the property, they need to sell the property. We even get landlords that use that process when there's rent arrears, but they don't want to claim for rent arrears at court, and it's used heavily when there is antisocial behaviour at a property. They're the 2 notices which we call at Landlord Action Step 1. If your tenants don't leave or pay after Step 1, then you'd have to go to Step 2 and arrange to issue court proceedings, which we do through our regulated solicitors. We'd have to file a possession claim at court and await from the court to get the claim issued and obtain a hearing date to get a possession order, a money order, and some costs from the court. That can take as much as 4 months now to get a hearing date because the courts are really backed up. If it's under Section 21, it's an accelerated procedure where you don't have a hearing date. I do anticipate that at the end of 2023, I think that there'll be in the excess of over 120,000 possession claims issued, which will be more than pre-COVID in 2019. The last step in Step 3 is if the tenant still doesn't pay up and still won't leave your property after having a possession order, is you'll need to apply legally for a bailiff to set down an eviction date. And bailiffs are going to be busier now with more landlord and tenant evictions and more house repossession evictions because of course the interest rates have gone up for homeowners. Normally one would be waiting for 8 to 10 to 12 weeks for eviction dates, but we've heard of some horror stories having to wait 4, 5, 6 months for an eviction date, which does not help the landlord because of course that's extra rent arrears which they're unlikely to be able to collect. We have a big housing crisis at the moment, and still we are seeing the councils telling tenants to stay put until they are evicted, which of course is having a big impact on landlords. Most landlords don't realise that evicting a tenant is actually a legal process. You can't try and do it yourself because there's so many ways of tripping up, from the Deregulation Act to making sure you're serving the notices correctly and issuing the possession claims at court, and going before a judge by yourself can be quite intimidating. So I would recommend that if you ever have to go to the last resort of issuing court proceedings and having to seek out professionals, use someone like us at Landlord Action who are regulated by the Solicitors Regulation Authority or a firm of solicitors. Do not use an unregulated eviction company, because it's really important to use a professional organisation. So if you want more information on how to prevent having a tenant in rent arrears or eviction, go and seek out more information on the Total Landlord Knowledge Centre.